2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the Tennessee Court of Appeals.
Good morning, Your Honor.
Appreciate each of you and your clients agreeing to participate by oral argument via Zoom. It's not our preferred method, but it is the method that is the best thing to do right now. Both of you are experienced practitioners, so you know the rules and procedures of the court, and we will proceed today as if we were all in the courtroom together. What that means essentially is each side gets 15 minutes to make its oral argument. If you are the appellant and you've reserved time with Mr. Hibner earlier, then you will receive that rebuttal time. Before we get started, though, I want to introduce your panel for this morning. We have Judge Arnold Goldman from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we call the case?
No, Your Honor.
All right, you may call the case then.
State of Tennessee versus Julia Hurley, Loudon County Commissioner for the 2nd Judicial District.
And we will hear from the appellant.
May it please the court, T. Scott Jones on behalf of Julia Hurley, the appellant. Your Honor, the principal issue I think is somewhat simple as far as for us to address. It deals with Tennessee Code Annotated Section 2935-110, subsection A, deals with quo warranto actions. In this particular case, we've outlined the history of why the action was brought and by whom it was brought, in particular, Henry Cullen, on information brought through the sitting elected Attorney General of the 9th Judicial District, Russell Johnson. In this particular case, when the action was originally commenced on March 26, 2020, we timely filed a motion to dismiss with regards to the failure of what we deemed to be the security. We contended, and we still contend, that the security was a prerequisite to the court having jurisdiction. We outlined that in our legal arguments. Unfortunately, the court did not agree with us. We had hearings associated with this matter, and there was an order denying the same on or about July 23rd. And then we had a subsequent hearing in which the judge called us back and readdressed these matters on October 21st, 2020. We requested a Rule 9, which was denied, and then this court was kind enough to allow us the Rule 10 relative to that. That being said, it is our contention that because of the fact that when a statute requires it, as it does particularly in 2935-110, that it is jurisdictional, and that if it is not given, that the suit would thus be void ab initio, and that any attempt pursuant to the statute 2012-124 or any other statute to amend or subsequently give security would simply be the amendment to a nullity, that you cannot amend a nullity, that if it was void ab initio or required at the beginning, that you can't do that. We cited a number of cases associated with that, and we would agree, as I believe the state does, that this is basically a case of first impression with regards to this statute. But we feel that the statute is clear. I mean, the exact language of the statute says the suit is also brought on the information of any person upon such person giving security for the cost of the proceedings to be approved by the clerk of the court in which the bill is filed. In this case, that didn't occur. The state actually concedes that in their response to our filings relative to this. The only thing that we've got is a bare promise to pay, and a promise to pay does not meet the requirements of security because nothing's been given in exchange for that promise. And that
Now that's been remedied, has it? Not Mr. Jones?
It has been attempted to be remedied, Your Honor. Yes, sir. The court discussed that and said, well, I think we're just going to allow the clerk to do that. But because of the fact that it's jurisdictional in question, what our argument would be is that they cannot then, if you will, remedy a nullity, that their option should have been to have gone back and recommenced the suit, that the suit then was null and void at the beginning because of the fact that you can't then subsequently give security.
Normally, if something is jurisdictional, the statute itself will provide that it is jurisdictional. Why is this different?
Your Honor, because I think the statute does provide that it's jurisdictional, because it says upon such person giving such security. That being said, that's required at the very beginning to commence the suit. It's very similar. We had cited basically the Hopkins case where we dealt with the issues with regards to landlord-tenant type situations, and albeit obviously a completely different type of law, it is actually the prerequisite to the court having jurisdiction. And in this particular case, we would submit that it's jurisdictional, and that because of the unique nature of this statute, they wouldn't have put that language in 2935-110 if it wasn't intended to be so. What's referred to by the state with regards to 2012-124 is a very general statute that talks about giving security at whatever time or whenever time is requested. But we would contend that statutory construction requires the interpretation be the, if you will, more restrictive statute be looked at first before you ever go to the more general statute.
Okay.
And for all intensive purposes, that's our argument. I mean, it basically boils down to those sort of simple steps, and that when you actually look at the original bond that was given, it's just a promise to pay. It's not security. There is no sworn security. It's what you would normally have in an action. Plus, Henry Cullen is a private citizen. He cannot be security for himself, as opposed to an attorney signing a bond or had the attorney general signed the bond. The only signatory to the bond in this particular cause of action is Henry Cullen himself. And so with that argument, we would submit that given the interpretation that we believe that the court should have dropped of 2935-110, that you can't subsequently go back and amend a nullity, that the more appropriate step would have been for the original cause of action to have been dismissed, and then the state be given their own devices if they wanted to go back and refile it. So that's our position, Your Honor, respectfully. Your Honor.
All right. Anything else?
No, Your Honor, I believe that adequately covers it. I believe we've attached all of the requisite pleadings and documentation, and I believe we fully briefed it both in our request for the court's consideration of our Rule 10, as well as in our brief on behalf of the appellant and our reply brief to the state's response.
All right, sir. Thank you. We will hear from the appellee.
Good morning, Your Honors. My name is
Morning.
Jason Barber. I'm here on behalf of the state of Tennessee, representing them on behalf of Russell Johnson, District Attorney General for the 9th Judicial District. Your Honors, I'd like to start out and outline and distinguish the differences in the three cases that the appellant relies on in their brief. Most specifically is going to be Jones versus Hopkins. In that case, the Supreme Court was addressing an appeal bond in that instance, saying that the absence of the bond resulted in the appeal essentially not being perfected and therefore being a nullity. It's unique and different from this instance. In this instance, we're actually dealing with a cost bond here specifically, and I'll outline 2935-110A in a moment. But the difference there is we're dealing with an appeal bond where there's already been a judgment rendered in the General Sessions Court, and that matter is being appealed to the Circuit Court. Next, they also rely on Sims versus Odessa Corporation. That is a failure to comply with Rule 4, saying that the summons was not served, and therefore it was a nullity from the beginning because the defendant was not made aware of the suit. Then next, they rely on State versus Ferrante, which is a criminal case in which is a failure to comply with Rule 3 of the Criminal Rules of Procedure, in which the the affiant was not having the warrant served or signed in the presence of the magistrate. Again, they failed to comply with Rule 3. Each of those situations is different than what we have here in this present case. When we look at the language of 2935-110A, it is the pertinent part is that upon such person giving security for costs or receipt to be approved by the clerk of the court which the bill is filed. And if we take what the legislator says and with purpose, and in this instance, they're saying they're directing the clerk to review that bond and determine if there is sufficient security to secure the costs that are associated with the lawsuit. So in particular, we're talking about the court cost, the litigation tax, and those that would be taxed to the county in the event that somebody failed to pay. This pertinent part is that the legislator is clear. If we look at this statute has not changed in over 100 years. So in this instance, and we're looking at the time, this is a time, and actually the trial court made reference to this in the record. It's actually in volume 2, pages 14 and 15. The trial court made reference to the idea that in times past, when communities were smaller, the clerk would know if somebody was good of their word. And so this is what it appears the legislative intent was here, is that the clerk of the court was somebody who would have known the citizenry of the county and known if somebody was going to make good on their promise to pay or not. The state does not believe that this is jurisdictional in nature, and the actual requisite jurisdictional part of this is it being approved by the clerk. It was approved by the clerk when the clerk accepted the petition for quo warranto for filing. If the clerk were to not accept it for filing, it would have been filed. We would not be before the court today. If the petition did not contain a cost bond provision, if that provision is absent in its entirety, then it would also be jurisdictionally void because the clerk would not have approved the cost, making this.
Let me ask you a question, counsel.
Yes, sure.
In this instance, I'm assuming that this was presented to the clerk and the clerk approved it. Is that correct?
Yes, Your Honor. This was taken to the clerk and master's office, presented to the clerk. The clerk reviewed the petition and then filed the petition and sent it to Mr. Jones.
Okay. And what is the status of this case now?
The current status of this case is the order from the Court of Appeals was staying this proceeding. The last activity that happened outside the motions hearings we had on the motion to dismiss was the state filed an amended quo warranto petition on the order of the trial court on August 28th of 2020, in which the trial court instructed the state to obtain additional security and get additional signatures. The language of the trial court in particular is on page 15 of the record, in which state inquired as to whether or not who needed to approve the additional security. And the trial court's words, I'm going to leave it up to the clerk. If the clerk thinks that the bond is good after the addition of surety, that's going to be acceptable to me, was the position of the trial court on the amendment.
Okay. So has the clerk approved the additional security at this juncture, or is that still pending in the trial court?
The amended petition was filed on August 28, 2020. So the state's contention would be yes, the clerk approved it with the additional signatures from other citizens of Loudon County.
Okay.
This issue has not come back up before the trial court outside of the Rule 9, and we did not address the additional security argument.
Okay. All right. Thank you.
If the appellant also contends that 2012-124 is not applicable in this situation, the state believes that 2935-110A is clear on itself that it can be additional security is approved by the clerk. And if the court finds that additional security should be ordered, as it did in this instance, that's sufficient. However, in the event that the additional security is not satisfied, 2012-124 makes it clear that any person required by law to give security for cause may at any stage of the cause be ruled to give such security, if not previously done. In this instance, under Mr. Jones's interpretation of 2935-110A, that the security for cause should have been provided at the front end, where he's contending it's not security, which the state's position would be as the clerk deemed that to be sufficient security, as she is aware of Mr. Cullen in the community and believed that he would pay the proceedings if it was ruled in favor of the defendant, but 2012-124 steps in its shoes and says that Mr. Cullen was the person who was ordered to give security. So if the court were to deem that he did not give security, it would be appropriate to order him to provide additional security. The state believes that the trial court was correct in its ordering and disagrees with the appellant's proposition that this is jurisdictional. This is something that could have been cured. If we look at the reply filed by the appellant, they cite to the fact that his promise to pay wasn't sufficient security. But if it wasn't sufficient security, then the clerk would not have accepted the filing and issued summons on the case. So at that point in time, when the summons was issued, the clerk did accept the filing and issued that cause. Now the court came back on the back end and said they agreed with the defendant in the proceeding and said that they did not believe there was sufficient security, and the state's belief rightfully ordered additional security to be provided and was justified in denying the defendant's motion to dismiss the proceeding. The defendant was not prejudiced by this in any manner. The only entity in which would be prejudiced by not receiving this additional security is actually the county, as they would be the ones who would be bearing the cost if Mr. Cullen failed to abide by his promise to pay the litigation tax and the court costs associated with this filing in the event the state did not succeed in its cause. If they also contend that the clerk and master did not follow the statutory language and they could have approved it. Again, the state's position on this would be is that the clerk had to approve the filing and therefore approve the security. Otherwise, the summons would have never been issued. Your Honor, I believe that's succinctly kind of covers the position of the state, recaps everything that's in our briefs and adds additional clarity that may be lacking in the brief.
All right, sir. We appreciate your argument. Thank you.
Thank you.
Mr. Jones, we will hear from you in rebuttal.
Yes, Your Honor. Briefly, as we indicated in our reply to the state's brief, we don't believe that the court should read the term security out of the plain language of the statute. And by the statute, I'm talking about 2935-110. In particular, if the court goes back, it is part of what the record is, Mr. Cullen didn't swear to anything. There is effectively no bond. A promise to pay is not a bond in and of itself. And if they wanted to say or to deal with it, it is upon giving such security. I mean, basically, it is a unsworn promise to, he doesn't give any security at all. We have indicated that basically a bare promise to pay is not security. And given the language of the statute, we don't believe it's appropriate that that just gets read out of it and that they subsequently get to amend. The case law that we had submitted with regards to that, obviously the Hopkins case, basically citing that it's jurisdictional in dealing with the issue, and that once it's jurisdictional, that if they don't do it, the court didn't have any jurisdiction to begin with. You cannot amend a nullity. And that basically is then outlined with the Sims case and the Ferrante case, in that basically those were attempts effectively by government actors to amend nullities or to address things that were void ab initio. In this case, we believe it would be void ab initio, and especially when you read the actual language of what Mr. Cullen did. In addition, we're confined to the record, and albeit I appreciate Mr. Culver's reference to the fact that he's sure what the clerk did or that the clerk did that. There's nothing in the record relative to the clerk approving this and this being security. And we have to read it on the naked facts of what's actually within the record. And there's just simply nothing there that this constituted security, any testimony from the clerk that she felt it was valid security, anything of that nature. And with that, Your Honor, we would contend that it was a nullity. It could not be amended, that the state had a matter when we brought it to their attention way back with our original motion to dismiss, that the appropriate thing would have been to have just started over. But they chose not to start over. They chose to continue to press forward. And with that, we don't believe that they can amend a nullity. We would ask the court to exercise its power to rule in our favor that, in fact, that it was void ab initio and that it should be dismissed for failure to comply with 2935-110.
All right, thank you. Thank you, both counsel and your clients, for participating in this Zoom oral argument today. We will attempt to enter a judgment at the earliest possible date, but we'll take the case under advisement now. We again appreciate Mr. Hibner and his staff and the AOC staff for making this argument possible. Mr. Hibner, if you will recess until the call in the next case, please.
This honorable court is now in recess until 11:30 a.m.
Thank you, gentlemen.
Thank you, Your Honor.
Thank you, Your Honor.
Well,